Hello everyone. This is going to be a lecture about the European Convention on Human Rights and, to a lesser extent, the European Court of Human Rights. So first of all, what of its background? Well, human rights goes back possibly to the Emperor Ashoka in ancient India, or indeed to Cyrus in ancient Persia. So some Westerners will be discombobulated to know that the concept of human rights actually comes from South Asia, possibly the Middle East. And indeed, the notion of the presumption of innocence goes back to ancient Babylonia, which is now Iraq. So, Ted Cruz, put that in your pipe and smoke it. But in the Western world, it's really the French Revolution that brought about 1789, the Declarations of the Rights of Man and of Citizen. So we have to have access to these rights. We have to have a document saying what they are, and we have to have a court which would provide us for these remedies. And in Europe, that is the European Court of Human Rights. I mean Europe, not the European Union. People so often conflate Europe, the continent, with the European Union. And people like Blair, a Europhile politician, was always doing this. So difficult for people like me, trying to teach people that Europe is a geographical entity, then there's the European Union, which is a political one, and they're not completely the same, though they overlap. But anyway, the European Court of Human Rights is for every country in the continent of Europe, not just in the European Union. Of the 45 countries in Europe, at its broadest definition, I think all 45 are there. The European Court of Human Rights has jurisdiction over certain matters in all 45 countries, but only when all domestic remedies have been exhausted. So we're going to look at the structure and the character of the most important articles of the European Convention on Human Rights, and the European Court of Human Rights adjudicates the Convention. So it's quite confusing because they're both ECHR. So I might just say the Court and the Convention for short. So there are certain core principles there, certain positive obligations which states undertake to abide by. There's a margin of appreciation, as in some leeway states have, and then proportionality is a guiding principle. Okay, we shouldn't do things in a disproportionate manner. So some people say there's natural law, these rights exist anyway, in which case why do we actually need to articulate what they are? How do we know they exist? Like nature, like biology created them? But anyway, people argue that there's natural law. I'm a skeptic, as you may have deduced. The Enlightenment came around, this intellectual movement in the 18th century. It ain't necessarily so. That's to say, no longer take things on trust, no longer accept the argument from authority. I am the authority figure, I'm the religious leader or the professor or whatever, and I say this, and then it goes, and you have to believe me unquestioningly. When the Enlightenment goes back to the Socratic method and says, question everything, question those in power, question authorities. Don't disbelieve them, don't believe them, question. They might be right, they might be wrong, but keep an open mind, and then use evidence to draw conclusions. Use your reason to guide you towards a logical conclusion, and try and keep emotion out of it. So this is liberalism in its broadest sense. Not exactly modern political liberalism, though it kind of led to it. Just about everybody in politics today is a small L liberal by 18th century terms. I know the word liberal didn't have a political signification in English until the early 18th century. So the Enlightenment had a great bearing on the French Revolution of 1789, or prior to that, the American Revolution of 1776. Though, of course, there were some spots on the sun in both cases. Anyway, let's fast forward to 1945. That October, the International Criminal Tribunal opened at Nuremberg, Germany. So Nuremberg was one of the few cities in Germany to survive largely intact from the war, being the site of various National Socialist rallies in the 1930s, and about 24 of the head honchos of the Third Reich stood trial for crimes against humanity, crimes against peace, and so forth. Churchill suggested they should be summarily executed upon apprehension, but others had talked him out of it, and the Allies had agreed that they would face trial, so Germany would see what a fair trial is. They're given defense counsel, it's not rushed, they're not mistreated, they never alleged that, and judges sometimes threw out evidence. Some of the charges were rejected, so they were acquitted on some charges. Some people were acquitted completely, and some people found guilty, obviously, and get sentences all the way up to death, and indeed about 12 of them were executed. This is to try and stop that atrocities happening ever again. Of course, these weren't the first atrocities to ever occur, and the adjudicating powers, the UK, France, the United States, the Soviet Union, had all committed atrocity themselves, often not long before 1945, and some of them afterwards too. So then the Universal Declaration of Human Rights was promulgated in 1948 by the United Nations, and Eleanor Roosevelt, the former First Lady of the United States, was a prime mover behind that. But is this merely an expression of opinion, or is it in any sense legally binding? It's a moot point. Moot, good legal word. You'll know what a moot is. It's a mock trial where budding lawyers hone their skills in advocacy in a faux courtroom. Okay, coming back to this Universal Declaration of Human Rights, Article 1 says that all humans are born free and equal in dignity and rights. Is that true? Is that an expression of opinion? Are we all free? I mean, it might be nice if we are free, but in 1948, many people were in slavery. Some states had slavery legally. Saudi Arabia, for example. Are they equal in dignity? Like, we'd like them to have equal dignity. Some people are not very dignified. Some people are incredibly dignified. On rights, I think this is ought to. This is aspirational, seems to me. Article 1 goes on to add, they are endowed with reason and conscience and should act towards each other in a spirit of brotherhood. All right. Do we all have reason? Some people have reason, this faculty. Others have less, others have none, I suppose. What about people of very, very low intellectual capacity and conscience? Some people, like Donald Trump, seems to have no conscience at all. They should act towards each other in a spirit of brotherhood. Why? Says who? Okay. So various jurists and diplomats and politicians said that, but there were these sentiments. I'm not entirely in agreement with them. Okay, so let's see how the Council of Europe responded. Okay, the Council of Europe is not the European Council. That's different. The Council of Europe was an organization set up for just about every country in Europe. I mean, there are about 45 now, as in everyone from, like, say, Iceland to Azerbaijan. But they weren't all members of the Council of Europe back then. So they drafted the European Convention of Human Rights in 1950. So its longer title is the Convention for the Protection of Human Rights and Fundamental Freedoms, ECHR, or we could just call it the Convention. So the UK was very involved. Some of the top law lords helped to shape it. And so in 1953 it entered force. So the Council of Europe has got every country in Europe with a single exception of Belarus. And so the adjudicating body for it is the European Court of Human Rights, which is in Strasbourg, which is not a European Union court. People very often get that wrong. Okay, and the Council of Europe is not the European Union. The European Union has got 28 states. The Council of Europe has got 47 states. So the convention has jurisdiction if there is a preliminary point. So remember, this is the first article of the European Convention of Human Rights. The high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1. Okay, the high contracting parties, that means the states which are signatories thereof. And who's in their jurisdiction? Well, that's people they control, not only in their own sovereign territory, but if they even temporarily control another bit of territory. Coming back to, say, the liberation of Iraq in 2003 and thereafter, say the British Army fighting there, if there's areas they controlled, remember they had in their custody, they had to guarantee that person's rights and freedom. Even that person's under arrest, they do have a bit of freedom, all right? They're not to be tortured, they're not to be killed unless absolutely unavoidable. So in Al-Scani and others, and against the United Kingdom 2011, 6 Iraqis were killed by the British Army. This is found to be in breach of Article 2. This was during the occupation of Basra, an Iraqi city, and there was said to be the requisite degree of control by the British forces there, such that it was contingent, or it behoved the UK to secure to these people their rights. So how much control do you need to have before it's a duty that that state has taken on? Well, this is the case which came up in R. Jason Smith and Minister of Defence in 2010, and was also considered by Smith Ellis and Albert and Ministry of Defense in 2003. Okay, because some people were saying, well, the United Kingdom didn't really control Basra. Yeah, the army was there, it just controlled little bits of Basra. The situation was in flux. It was completely anarchic. So it couldn't be said the United Kingdom really controlled Basra. Therefore, the United Kingdom was not obliged to uphold the rights of the people there. Anyway, so there can be derogations. So let's look at Article 15 of the Convention. No derogation is possible from Article 3, for example, which prohibits torture. So no matter what the circumstance, you can't say, in extremis, we're allowed to do it. No, you're not. Maybe you think that's wrong, but that is the rule. Okay, no torture at all. Or inhuman and degrading treatment. Okay, things which are a bit less than torture these days, considered with stress positions, things like that. Hooding you're not allowed to do. That's been regarded as inhumane or degrading treatment since the mid-70s. Okay, the UK stopped hooding suspects in about 1973. The United States military was hooding them just a few years ago. I don't know if they've decided to stop. They might not happen to be doing it now, but they were certainly hooding them in Iraq, right till the end of their significant presence in Iraq. Article 2, you're not to kill people unless it's lawful in war, unless it's some sort of urgent situation. The armed police have to confront people in a hostage situation or a terrorist situation. Minimum force. Don't kill people unless absolutely unavoidable. There are other articles where you can derogate in certain situations. Say this one doesn't apply temporarily. So you can disapply some of the other articles, as it says. This is from the Convention. In time of war or public emergency threatening the life of the nation. Now, coronavirus could be argued to threaten the life of the nation. Is it so bad it would kill so many millions of people? The UK, for example, could effectively cease to exist. You might see if you could sustain that argument in the courtroom. Or indeed, point 2, when it's strictly required by the exigencies of the situation. I mean, exigency is the same as emergency. So there's another case, A and others, against the Secretary of State for the Home Department in 2005, or Ireland against and the UK in 1978. 1978, the Irish government, we took the UK to the European Convention on Human Rights, saying that people in Northern Ireland, some suspected members of the IRA and INLA, had been abused in custody, claimed they'd been tortured. The European Court of Human Rights, they initially found the UK had tortured people. On appeal, they said, no, it wasn't torture, it's not that severe. So about hooding, stress positions, white noise, and so on. And this happened to, I think it's only 4 individuals this is proven to have happened to. And so that was that. Okay, so we'll see what standing there is. Under Article 34 of the European Convention on Human Rights, it says that any person, non-governmental organisation, or group of individuals claiming to be a victim of violation, these people have a locus standi. These people can have their case heard by the European Court of Human Rights. Or there's another example, the Sunday Times and the United Kingdom in 1979, when the Sunday Times newspaper claimed that its rights were abused by the UK government, or Class in Germany in 1978. So a victim is any person or indeed a group of people who claim they were directly affected by a potential violation. Notice you can't be indirectly affected by a potential violation. So come on to Articles 2.42. There's key rights and liberties. And the majority of these involve presumptive rights. That's to say there's an element of qualification here, a little bit limited, that might vary from state to state. So in Articles 8 to 11 are qualified rights, which is to say that they are restricted and they vary a bit from one country to another. Article 5 has got a limited right, and Article 3 says, as I said, it completely outlaws torture under all circumstances. You can't plead, well, this is a special case or there's a ticking bomb scenario. No, this is crystal clear, no matter what the situation, not allowed to do it. Now you might think that's extreme. Well, we need to. We got the suspect. We know a bomb is going to go off somewhere in the city. We don't know where it's going to go off. He knows. Let's torture him till he tells us where it is and we can go defuse it. And if we don't, he's going to kill lots of people. Rightly or wrongly, the European Convention of Rights says, nuh-uh, no way, no matter what happens, no matter how many lives it would save, you're not allowed to torture. You might think that's daft. Hurt one guy a little bit, save many lives. Which should you do? It's a no-brainer. But they say, well, that's the thin end of the wedge. Before you know, you'll be torturing people willy-nilly on the off chance. So they know something. Well, let's come back to the central principles of the Convention. So there's got to be, number 1, a positive obligation, number 2, a margin of appreciation, and number 3, proportionality. Okay, so positive obligation is you've got to actually do something as a state. Number two, margin of appreciation. Sometimes states are allowed to do things a little bit differently. States might interpret something more broadly, another state interpret it more narrowly. And last of all, proportionality. Things have got to be done in a proportionate manner to achieve the objective set. Okay, so let's come back to some of these. There's X and Y and the Netherlands, against the Netherlands in 1986, or Chahal and the United Kingdom in 1997. That was a Sikh gentleman of Indian origin who was in the United Kingdom. He'd been involved in the movement for independence for Khalistan, the so-called Sikh homeland in India, fighting against the government of India. But he said he'd been arrested, he'd been tortured, he'd come to the UK, India sought his extradition, saying he's a terrorist, but the British court said there's a considerable chance he would face torture, inhuman, degrading treatment. No, he can't be extradited. Okay. Or the Soering and the United Kingdom in 1989, or indeed Osman in the UK in the year 2000. A margin of appreciation. This is an interpretive principle, and the court in Strasbourg is aware that there are national, regional traditions, and it allows for that, to do things a little bit differently. Handyside in the United Kingdom in 1976 would be a case, or A, B, and C against Ireland in 2010 would be another case. All right. So values, they evolve over time. The convention is perceived as a living instrument, so it changes. The interpretation must be purposive in order to give effect to the fundamental aims of the European Convention of Human Rights. They have regard to the circumstances of each case. So bear in mind there is a distinction between international level and domestic level, the margin of appreciation. For example, R and DPP ex parte, Kabbalah in 1999. It said an area of judgment within which the judiciary will defer on democratic grounds. That's what Lord Hope said. So again, the court doesn't wish to stray into the political arena and say, well, this is a decision for politicians to decide and we can't be too precise about things. So there's certain parameters, keep you in that parameters, but they're not going to say where exactly you should be within those parameters. So in the case of Soering and UK, this is what the court had to say. Inherent in the whole of the convention is the search for a fair balance between the demands of the general interest of the community and the requirements of the protection of the individual's fundamental rights. So think about that. There's the individual on one hand, and there's the community on the other hand. And sometimes what individual rights and community rights clash. You know, there's some sort of lockdown. For coronavirus, I want to go out, socialize, whatever, with a group of people. My individual rights being deprived, being taken away from me. But if I do that, I might get coronavirus and spread it on to others and so on. So we've got to think about the well-being of the community. So what should the court decide? Well, there's more of a political, medical decision. And so we'll leave it up to the member state within reason about how much they're allowed to infringe upon individual liberty, or how much they're allowed to disregard the common weal. Okay, so there's another thick case, Handyside in the United Kingdom in 1976, where they had to answer whether interference was about a pressing social need, and is something proportionate to the legitimate aim that you're seeking to achieve. So you're pursuing an aim, let's say it's not on Handyside, trying to limit the spread of coronavirus. But if we had a total lockdown for a year, would that be proportionate? That might be excessive, or maybe not. Okay, so look at the Freitas Test. This was adopted in R and Secretary of State of the Home Department ex parte daily, 2001. So this is what Lord Steyn laid out. He said that sometimes there's a legislative objective which is so vital that it has to limit a fundamental right, and have to look at whether the measures that are intended to fulfill this objective are rationally connected to it. Because there might be a measure that you're adopting, the government is adopting, which is not rationally connected to the measure they're trying to achieve. They might be just using some sort of smokescreen to push through another policy. And then you have to ask whether the means used in furtherance of the objective impair a right excessively, whether they impair it more than they actually need to in order to achieve the set objective. it's all a bit hypothetical. But coming back to the coronavirus example and the 1-year lockdown, you might say that is depriving me of their rights to an excessive degree, even bearing in mind the aim which they're seeking to achieve, which is to stop the spread of coronavirus. And we could say we have to stop the spread of coronavirus, therefore we're outlawing alcohol. You might say, come about, that's got nothing to do with it. You're abusing this coronavirus crisis for the sake of doing something unconnected to it. Or there's another case which is quite relevant to this, Bank Mellat and His Majesty's Treasury No. 2 in 2003, and Lord Reid had to consider something similar. Okay, so coming back to the European Convention of Human Rights, remember the Human Rights Act transposed international law. There are certain treaty obligations, and remember the UK is a dualist country, even though it signs a treaty that doesn't automatically make it part of domestic law. And so the rights of British citizens are there. They can petition. In the European Court of Human Rights, 1966, for the first time, a case was heard relating to the UK, Malone and the United Kingdom. With a feeling in the late 50s, some IRA terrorists who were interned, they said that their liberties were being taken away, and the European Court of Rights decided, no, this is proportionate, that's a legitimate aim, the protection of public security, and under certain circumstances, habeas corpus can be suspended for a limited period, and so, no, your rights have not been breached. So some people were saying that the UK ought to incorporate the European Convention of Human Rights into domestic law. Lord Leicester and indeed Lord Scarman were saying so. Anyway, so the Human Rights Act was passed in 1998 under Tony Blair's Labour government, and they said they were bringing human rights home. So it took effect in 2000 in England, Wales, Northern Ireland. It took effect in Scotland the year before. So Section 1 of the HRA said that the ECHR, the convention, was incorporated into British law, not just English law, British law, and you can compare that to the European Communities Act of 1972. But then there was one exemption, that was Article 13, which said you had to provide adequate remedies. Well, that is a very brief introduction to the European Convention on Human Rights. So please book online lessons with me in law and lots of other subjects. Check out my main channel, George from Ireland, on YouTube. Just look up George from Ireland. Toodaloo.